And Wairimo is a sign language interpreter. I am Muthoni Minor. Now, starting off, BBI proponent President Uhuru Kenyatta and his handshake ally Raila Odinga have suffered another defeat in court after a 7-judge bench of the Court of Appeal upheld the High Court judgment that nullified the BBI process. The bench, presided by Court of Appeal President Daniel Musinga, dismissed nearly all submissions by the appellants and declared the constitutional amendment process unconstitutional. ODM leader Raila Odinga has already embraced the Court of Appeal judgment but did not say if the proponents of BBI will move to the Supreme Court or not. Our reporter David Muthoka has been following the judgment at the Court of Appeal and now joins me live with the latest. Muthoka, a long day indeed, and it could be a long night for BBI proponents, right?
Well, Muthoni Minor, indeed, it might be a very long night for the BBI proponents. But just before we get into how long the night might be, let's look at how long the day has been. Remember, this particular judgment began at around 9 a.m. and came to a close at around a few minutes to 8 p.m. So nearly the entire day was spent as not only the proponents but the opponents and us journalists stayed here listening to judgment after judgment from the 7-judge bench in matters the BBI consolidated appeals. Now, Muthoni Minor, about what a long night it might be for the BBI proponents who are the appellants in this case. Remember, this particular situation comes barely months after the High Court dealt the BBI process, otherwise known as the Constitution Amendment Bill 2020, a blow at the High Court. Remember, 5 judges of the High Court termed the entire process as null and void. And today, their senior counterparts, that is the 7-judge bench here at the Court of Appeal, led by President Daniel Musinga, have done what seems like landing the last nail on the BBI coffin by upholding that particular judgment that ruled BBI as null, unconstitutional, and void. But just before we continue, maybe we can listen to what the judges were saying and the respective judgments from the 7 judges.
That President Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. 2. That Article 257(10) of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct questions, referendum questions to the people. Nambuye, Okwengu, and Kiage JJA descending. 3. The BBI Steering Committee established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette of 10th January 2020 is an unconstitutional and unlawful entity. And lastly, the cross appeals fail and are hereby dismissed.
Indeed, Muthoni Minor and our viewer, that was the situation here at the Supreme Court of Kenya, which was the venue for the Court of Appeal that was delivering judgment on the BBI consolidated appeals. Muthoni, remember, these consolidated appeals focused on up to 20 questions, but there were some questions that were in need, and thus those that were contended, including whether the president can initiate a process, a constitutional change, a popular initiative, as in his official capacity. Remember, those that defended the president had said that he had done that as a private citizen. But again, the Court of Appeal found that no, in no way was the president acting as a private citizen, but he did that in his official capacity, which contravenes the Constitution, because the president in no way can initiate a popular initiative through or rather can initiate a change in the Constitution, an amendment in the Constitution through popular initiative. Muthoni Maina.
Indeed, Muthoka, as the appellant's brief in his remarks after the judgment, did you manage to speak to him on the sides, and what did he have to say?
Indeed, Muthoni Maina, Senior Counsel James Orengo, who is actually was actually part of the defense team that is pro-BBI, was spared a minute for us. We spoke to him just to get his reaction, and not him, we also spoke to other pro and anti-BBI teams that were here in court today, and maybe we can listen to what they had to say.
I think we are still at work, and I cannot say that this is the end of the road. I am sure about that.
Maybe are you planning to adopt the IPPG model as being proposed by Mr. David?
We didn't have a bicameral parliament. Now we have a bicameral parliament. We have a president who is not a part of parliament. These are different circumstances, so it will require, different solutions. But I want to say, ultimately, if you look at the content of what was proposed in the bill and the various statutes, these are pro-people issues and things that needs to go back to the people for advancement. And hopefully we may end up in court again. I mean, the Njoya process stopped the constitution-making process. This is such a case. It stopped the constitution-making process, but it didn't end it, because we went back to the people, and going back to the people set up a new constitutional making process and the framework for it. So I think we still go back to the people.
Well, first of all, as you know, this is the Court of Appeal, and there's always the right of appeal to the Supreme Court. So it is possible to appeal to the Supreme Court, and that we will have consultations in that. So you cannot say it's an end to it. Secondly, the BBI was an initiative. It contained certain proposals. You can always revive those proposals. You can revive and see which ones can be passed in Parliament without a referendum and which ones cannot. But in any event, what the court has said is that there are certain steps that need to be taken. There are certain ways of initiating it, and it should not be initiated by the president. So in theory, the only way one can say that is if they tie the BBI to the next general election. But the ideas in BBI can always be revived, because they were for posterity. They were not just for the next general election.
Yeah, and it is 11 months to that general election.
Yes.
So is it doable?
No.
Is it possible to still salvage the BBI process, have the proposals enacted before we go to the next election?
It is definitely challenging in terms of timelines. The BBI proposal reduced the time to like 6 months. And ideally, it becomes very challenging if you go to the Supreme Court, unless the Supreme Court was able to act much faster than the Court of Appeal. So in theory it is. But I think for us as a party, and Raila Odinga has already issued a statement on this, we are focusing on moving on. And we are focusing on continuing the conversation in BBI even beyond 2022. So it's not so much a worry of, do we have to do it now, do we go to the Supreme Court? It is a worry of, even as we now focus on the other issues in terms of the presidential elections and the general elections, is to focus and continue the conversation of BBI, whether it comes before 2022 or not.
So we expect to see appeals. We think that parties will appeal, but for us, we don't think the outcome will be much different, because we've had, I think these are now 12 judges expressing their minds, and a majority of those 12 judges, in fact 11 judges, largely making the same decision. And then at the Supreme Court, it's based purely on questions of law, so that the grounds are narrower, and I think the same outcome will come out of the Supreme Court, though it's difficult to tell, could go either way. Yeah. Thank you so much.
Indeed, Muthoni Maina and our viewer, you can hear those were the reactions from both BBI opponents and BBI proponents. And as you heard from James Orengo and Otiende Amolo, who are part of the BBI proponents, they say that in as much as the BBI reggae might have been muted by the Court of Appeal in conjunction with the High Court, they insist that the studio is still open. Perhaps next time we can see a BBI rumba, Muthoni Maina. So they say it is not indeed the end of the journey. They might have lost the battle, but they say that the war is far from over. They insist that surely the war is theirs to win, Muthoni Maina.
In Haminwa declared victory to the Constitution and the rule of law and not the rights activists he was representing in the appeal. Was that the general feeling from the lawyers present?
You know, Muthoni Maina, with this battle, there were two outcomes. One outcome seemed to go in favor of one legal team, and the other outcome seemed to go into the, didn't quite seem to favor another legal team. So it's an entire bittersweet feeling that was seen here at the Supreme Court of Kenya, which was, indeed, as I mentioned, the venue for the Court of Appeal judgment today on the BBI consolidated appeals. Because it is bittersweet, because for one side that seemed to have won today, it knows that perhaps this case now might advance to the Supreme Court. The BBI proponents, in as much as you had one of the proponents, that is ODM boss Raila Odinga, will not want to go to the Supreme Court, but we might see other appellants, including the Attorney General, the President, the IEBC, move to the Supreme Court so that they can try and make their case in front of the judges at the Supreme Court. So one feeling is we are excited. Yes, we might have won, and as you heard, they know very well that indeed the war might be far from over. They might be headed to the Supreme Court, and there again we expect another bare knuckle duel pitting these legal teams, as we saw at the Court of Appeal, Muthoni Maina. But yet it remains a matter of time. We shall see what happens.
Indeed, with that bittersweet feeling, you know, the verdict sort of vindicated the High Court bench, or did it?
Indeed, it did. It sort of vindicated the High Court bench. The 5 judges, remember, they unanimously termed the entire BBI process in the name of Constitution Amendment Bill 2020 as null, unconstitutional and void. And we saw most of the judges here at the Court of Appeal uphold similar decisions, in as much as we saw some dissenting voices from some of the judges, not as many, but one or two. But most of them seemed to concur and endorse and uphold what was agreed and what was decided and ruled at the court, or rather at the High Court. Muthoni Maina.
Thank you so much, David Muthoka, for keep giving us